following program is classified G. It's suitable for all ages.
Tonight, we discuss the legal framework governing the gruesome murder of a Sri Lankan Priyantha Kumara in Sialkot, Pakistan on the 3rd of December 2021. The whole world was struck with shock given the nature of the crime, which unfortunately had repeated last week. In the midst of these inhumane acts, what exactly are the protections available for Sri Lankans living abroad? Will the perpetrators be brought to justice? And can the family living in Sri Lanka expect reparations for these gruesome crimes through legal tools? Land and Liberty, where we are keeping with the promise of bringing in a contemporary motion to discuss the legal provisions for certain things that the Sri Lankan community may not fully understand. And this week we have taken a sensitive topic, a bit of a pertinent topic, something that happened last year, actually in December, and was brought back into the public's discussion last week, given the fact that another incident occurred within the same country, and we are talking about the lynching incident in Sialkot. Now, the victim from the Sialkot incident in December was a Sri Lankan named Priyantha Kumara. We had excessively covered this within our channel as well. Something that we are trying to extract from this is now when crimes occur abroad, what exactly are the provisions that we as Sri Lankans should be looking at? What are the provisions that are available? What are things that are not clear to us? And to explain all of this, we have with us a very special guest, a guest that is, this program also becomes very special to me because one of my own lecturers is here for the very first time. President's Counsel, Seevali, Amithirigala, is a lecturer in laws and quite prominent within this field. Thank you so much, sir, for joining us today.
Thank you very much for having me. It's my pleasure coming here.
Thank you, sir. Before we get into the discussion, we are going to give a small breakdown to our viewers so everyone understands where we are going to head with this topic. Firstly, we are going to talk about the treaties, the law of treaties that are in play here, what exactly, when it comes to things like extradition, what exactly we should be questioning, what exactly we should know of. Second, we are going to talk a bit about diplomatic immunity and what the provisions are within current status quo, what the international treaties, conventions are pertaining to that as well. Then a move to the role of international courts. Now, this is something that has been said over and over again, something that is not, let's say, uncommon to Sri Lankans, but maybe a little unclear to how Sri Lankans really understand it. And finally, we are going to talk about the remedies that are available for crimes committed abroad.
Hi, my name is Vishal and I'm a student of psychology, and my question is on law of treaties. What are the existing multilateral treaties that govern criminal offences abroad?
All right, sir, once again, thank you so much for joining us. A lot of things to cover in this topic, something that has been within the public forum for quite some time. And many wouldn't really understand the repercussions of this. Many wouldn't be too clear about it. Now, sir, you have been in this field for quite some time. You have been lecturing, teaching a lot of students about this as well. On a practical level, if we give sort of like a introduction to this topic, where do we begin? What are the treaties in place, sir?
Yes, I think before I commence a discussion on this academic discussion, perhaps, permit me to pay my condolences to the family of Mr. Kumara, because he's a Sri Lankan, a compatriot, and I know how difficult it must be to face this situation. So let me pay my condolences, respects to the family and begin with. First and foremost, it is very important to understand that when we sent one of our nationals to another country, what sort of protection that national is entitled within that particular country. Permit me to go into a little bit of international law in this, because if you take, for example, a country like the domestic law and the domestic jurisdiction, if a person commits a crime, it's very easy, if I may say easy, I would think it is much more easy to enforce the jurisdiction, because you can arrest the person, you can bring him to court, charge him, take the evidence that is against him, call his defense case, and then at the end of the day, make a judgment. This becomes very much complicated when it is international law, because your enforcement jurisdiction does not go into another country. It is only within the territory that you will find your enforcement jurisdiction. So it is very important to understand the two levels. Number one, from the point of view of the domestic jurisdiction, it's much easier, but when it happens to one of our citizens outside Sri Lanka, it becomes a bit complicated because we don't have our enforcement jurisdiction over, let's say, for example, Pakistan. Also, Pakistan is a very friendly country. We don't want to upset diplomatic relations with Pakistan. So what we need to understand, I suppose from the point of view of the layman, is to see what sort of criminal jurisdictions does international law have. Under international law, there is also, there are five areas or theories of jurisdiction for criminal law. And you can take the first one, the territorial principle. Under the territorial principle, if the crime occurs, let's say, in Pakistan, as in this case, Pakistan is the country which is more convenient to gather the evidence, to arrest the accused, and to conduct the case according to due process, according to their constitution. That is called the territorial principle. Now, with regard to the territorial principle, a bit of a complication arises because there are two. Number one, objective and subjective. Objective means where the crime is completed. Subjective means where the crime is begun. Suppose if it is in two countries, for example, the slaying of the former Prime Minister of India, Sri Rajiv Gandhi. It was hatched in Sri Lanka, concluded in India. So in a situation like that, you would have both these principles applicable. So territorial principle is the first one. Second one is the nationality. Let's say if a perpetrator of a crime is of a particular nationality, that particular country can bring that person within their jurisdiction and then have a trial against that person. The third would be the passive personality principle, where our nationals who are living abroad are harmed by somebody who is not one of our nationals, like in this case. Yeah. Then we also can assert jurisdiction in that. Fourth one is the protective principle. Protective principle is really not associated with what I am talking today, because if our national security is being prejudiced by somebody outside, then we can assert jurisdiction. The last, but the fifth one that I want to talk about is the universality principle. This is where the treaties come as well, because some of the offenses where universality jurisdiction is available is under customary international law, like slavery, crimes against humanity, crimes against peace. But of course, there are treaty-based offenses like genocide. Now, anywhere you find a criminal who have committed an offense for which there is universal jurisdiction, you can try the person there. I would like to basically bring to your attention that there has been a case that the Frankfurt Regional Court has convicted an ISIS a member of the ISIS for basically killing a Yazidi girl by exposing her to bare sunlight after sexually assaulting her and abusing her. And he was convicted, and for information's sake, the lawyer who appeared for the mother of this girl is Mrs. Clooney, a very well-known lawyer married to a celebrity. And also recently we have found that there is a case that is being conducted against a national of Myanmar in Argentina. The case is going in Argentina for committing crimes against the Rohingya people. So you could see this is where the international law lays. If somebody commits a crime against one of our nationals who are abroad, all these provisions are available. I would think in this case, this is actually, it's a horrific crime. This would essentially come within the universal principle of jurisdiction, and therefore jurisdiction can be asserted on the ground. But permit me also to say, at the moment, Islamabad and the government of Islamabad are conducting their investigations and the due process according to their law. I think diplomatically this country also has agreed that the trial should go in Pakistan according to Pakistan law.
Mm-hmm. So if I, just to go in the offset of our discussion, the next step for the aggrieved parties within Sri Lanka would be diplomatic. Is that something that we have to really understand, or is there another process, some other institution that they can reach out to? Yes,
at the moment I think the Pakistani government has also reached out, from what I saw in the media, towards the victim's family. As you say rightly, you know, as I said, the enforcement jurisdiction doesn't extend beyond the boundaries of a country. You know? So we have a special apparatus of getting things done, and that is through diplomatic channels. We have ambassadors, we have consulars in those countries, and with these with the relations that we have with these countries, we would be trying to see the best we can get for the victim's family. Remember, the relationship between Pakistan and Sri Lanka is a very dear and a very important relationship. And we wouldn't want to jeopardize that, and neither would Pakistan want to jeopardize it with us. And it is very, very important to say that the Prime Minister of Pakistan has taken the necessary steps to bring the perpetrators to justice, and their ordinary legal system should take its normal course. We wouldn't want to interfere, because one thing is it's a sovereign country. Secondly, let it not be prejudiced. Let there be a fair trial at the end of the day. But what is alarming to me is, as you, at the beginning of this program, you said, as I'm also made aware, that there has been a lynching incident afterwards too. So this is a matter that Pakistan should really consider and worry about, because according to them, or according to what is happening in Pakistan, even the Pakistan law is not taking its course. So it's up to them. But as you say, perhaps before we send our people out, we can make our people aware. Look here, you are going to go for a job. It's not only the salary that matters. What matters is how you are treated in that country. Do you have safety? Do you have your basic rights being respected? This is very important, number one, from the part of the government to make people aware. And may I also say this, we always look up to the government and blame the government if certain things are not in order. Look, blame is due where it is worthy to be blamed. I certainly don't retract from that. But we have a duty on the part of us as nationals, citizens who are going to offer our services to another country. And I think it's important that the Sri Lankans don't look at it from the point of view, oh my God, I'm getting so much of money, so I'm happy to go. It's not only the money. And we should not do it because we are giving some value to ourselves by giving our work to them. So we need the protection that needs to be done. So therefore, it's very important to understand that there should be MOU signed between these nation states, ensuring not only the working conditions, but the safety and the dignity of the human beings who are being sent there, or the nationals that are sent there.
So as a final question for our first segment, something I want to clarify is, within certain constitutions we have seen within other countries, they flaunt the sort of protections that have been awarded to their own citizens. Now, a question that Sri Lankans would ask, even this specific family would ask, is whether those protections are available in the Sri Lankan constitution, whether the Sri Lankan constitution protects individuals who are going to other countries, or is that, again, as you very rightly mentioned, those diplomatic channels should be enforced, we should foster those relationships, and in those treaties we should make those things specific. Is that the situation? Yes,
I think it's a very important question that you raise. A Sri Lankan national will have all the rights that he will have under the Sri Lankan constitution, whether he is in Sri Lanka or outside. But the enforcement of those rights will have to be strictly within our boundaries. Let's say, he won't lose rights merely because he leaves the country. He has his rights. But for us to enforce, our enforcement jurisdiction, go arrest, take people, bring them to court, will not happen if it's beyond the boundaries of our country. So it's very important to understand we do protect people who come from other countries in here, and we expect through diplomatic channels to protect our people who go there. Diplomacy is all about reciprocity. If you don't protect my citizens, then who are in your quarter, I will not also give that commitment to protect yours. So this reciprocity is an age-old concept, and we have to resort to diplomatic channels to enforce those rights outside Sri Lanka. I don't want to use the word enforcement jurisdiction, because we have no enforcement jurisdiction other than the Interpol and the international agencies. We can't have our law enforcement agencies going outside our boundaries.
All right. So I think a lot of important aspects covered there, and a good introduction given to our topic. We'll take a very short break. When we return, we will talk about the diplomatic immunity and what exactly the provisions are there within the law, within international treaties. For that, you're with Law, Land and Liberty. Stay with us.
My name is Pramukh, and I'm an Logistics Executive. My question is on diplomatic immunity. How is diplomatic immunity identified in international law?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Seevali, Amithirigala. So our next segment will primarily be based on diplomatic immunity. Now, a lot of people have different interpretations of what diplomatic immunity is. Really not clear about what exactly the rights are awarded, whether they are above the law, whether individuals somehow there's some form of a different channel. But before that, I think you touched on something very interesting and very important, which is the enforcement jurisdiction aspect. Those Sri Lankans or the Sri Lankan paramilitary forces or any security force cannot enforce it. There are other organizations available. If briefly you could mention what exactly the structure is there, what sort of what is the sort of mandate, because these are also things that these greed parties would think about, you know, yes. if they are not getting the justice they deserve, whether there are other institutions that they can reach out to.
Yes. Now, before we go into the enforcement of international law, may I be permitted to say the following? You know, the easiest way was to apprehend a person and bring within the jurisdiction.
Yeah.
So, as you would see in the Eichmann case, they apprehended the criminal, brought him within that particular territory and asserted jurisdiction. This illegal apprehension of criminals is not something that is warranted under international law, but it happens.
It happens.
So, it's very important to understand, to prevent that, it's better to have an extradition treaty. If you have an extradition treaty, assuming that there is an offense that is committed, you can request that person to be handed over to you to try. But of course, few principles will apply. For example, you know, if it's double criminality, if the sentence is going to be the same as what you would give, then I think extradition would be permitted. No extradition for political offences and so on. So there are some exceptions there. But what is important is to go by international law. But we've seen that a very important case in the British House of Lords, R versus Horseferry Magistrate Courts ex parte Bennett, where it held, if by chance there is an extradition treaty between two nations, illegal apprehension should not be permitted. Actually, illegal apprehensions are illegal, but it happens.
Sorry.
Two things are violated when an illegal apprehension happens. Number one, the sovereignty of a nation. Secondly, the human rights of the person, because the person is brought by force. But you would remember that even the killing of Osama bin Laden was something that they went into Pakistan. So they violated the airspace of Pakistan. So this happens. So that would be one of the most forceful ways powerful countries would be implementing it. But I think if you go through the channels, it should be an extradition treaty. On the other hand, you spoke of diplomatic immunity. Let's take the Vienna Convention on Diplomatic Relations. Under Article 4, one of the important functions is to protect your nationals in that country where you are the missionary or the mission. So in that is not only inviting them for diplomatic functions, ensuring that they're safe, you have a count of how many people are there, their information is with your embassy, you check on how they are performing as well. At the same time, you have consular staff, a consular, under the Vienna Convention on Consular Relations, you would also have certain provisions, like for example, you would have provision Article 31, I believe, and also Article 36 and also Article 5G, which basically speaks about protecting your nationals in that country. So if the ambassador is involved in state activities with the other state, the consulars will be involved. They will go and see. Let's say now this case stems from a charge of blasphemy. You know? If Pakistan's due process was activated, there would have been charge preferred, the person arrested. Then our consular staff would have contacted this particular person, gone into the prison, taken information from him, given him legal advice. Then there would have been a fully fledged case going. That is what the diplomatic channels provide for. So when those channels are available, we would think those are the channels through which you have to go. But there is this exception of powerful states who will take the law into their hands. You spoke about Interpol. That is the most effective method of bringing criminals into law enforcement. And Interpol is a very important agency through which we can basically make accountable by arresting certain criminals and bringing them to justice. So the network is not straightforward, to be very honest. The network exists. The reason why I say it's not straightforward is that although international law is a law, international relations takes precedence over that law, unfortunately. And when international relations take over, there is no proper channel that they would go, although the prescribed channels would be extradition, Interpol, even for that matter in diplomatic relations, in handing over criminals. Apart from an extradition treaty, you saw the Julian Assange case some time ago, etc., etc. So you have very many circumstances and facts, and international situations have reacted to facts and circumstances rather than an established rudimentary law.
Right, so something that you brought about and something that we need to clarify, even though it will take a bit of a step away from the criminal aspect of this entire discussion, would be diplomatic immunity. Now, how exactly is that awarded to someone? What exactly is the mandate that is provided when it comes to diplomatic immunity? Does that also fall onto some sort of bilateral relationship, or is it international recognized?
Yes, it's a very, very good question. You know, when you have a diplomat in your country, you are treating him as the manifestation of the head of state of that country. That is why the term excellency is used. So all the treatment should be at the level of the very, very important person level, which means the head of state. So if a head of state was performing his task in this country, a foreign head of state, he would not be susceptible to the jurisdiction of this country. Therefore, he will be entitled to immunity from jurisdiction. He will be entitled to privileges. So all those immunities, privileges, and there's one more word, there is inviolability. We use the word inviolability, which is ascribed, given to the ambassadors or the high commissioners. Article 22 of the Vienna Convention ensures that the diplomatic premises, ensures not only the diplomatic archives, the premises, the transportation, modes of communications are all inviolable, which means the receiving state's enforcement jurisdiction should not be unleashed on those parties. At the same time, the receiving state is duty bound to ensure third parties not interfering with the diplomatic functions of that mission. I think very many cases are there, starting from Iran versus USA and many other cases subsequently coming in. What is important is that immunity is given to them on a functional basis. For them to effectively function, you need to give their immunity. Because if a nation state was going to enforce their jurisdiction over the ambassadors, there will be no impartiality for the ambassadors to conduct their duties. And they wouldn't allow our ambassadors to also perform our, as I said earlier, it's a reciprocal duty. So although immunity will not be directly linked to Mr. Kumara's case, I must say that the Sri Lankan ambassador there has taken effective action immediately afterwards. And also I think the Pakistan institutions thereafter has taken effective action afterwards. But permit me to say this, if you go through the clips, I'm going back into the situation. If you go through the clips, you can see Pakistani police officers also in the scene. So as I said again, I'm giving a word of caution to the government of Pakistan and also the Honorable Prime Minister of Pakistan. It seems that all is not well in Pakistan, not only for foreign workers, but even to individuals who are their nationals. Because if the law enforcement agencies have to stand by and look at something so horrific, diabolic happening, I think it's a very sorry state of affairs.
Sir, something that we, just to revisit something that we mentioned about the Interpol. Now, is that association, that relationship something with the Interpol, something that the country has? Or does individuals have some form of capacity to engage with the Interpol when exercising their jurisdictions? Is there some method of complaining? Is there some method of reaching out to the Interpol? Or is it something that you should do via your diplomatic channels, maybe through an embassy, maybe reaching out to your own government? How does that entire operation work?
Yeah, that's a very good question also, because when a crime occurs, you will have a statement generally made to the police of that territory where the crime occurs. And then, of course, that particular complaint will be the basis for the criminal proceeding and move. In this case also in Sialkot, the police was notified, there is complaints, now they have arrested, and there is also a trial which is impending. Generally, the Interpol can also be notified by the courts of a local, of a country. For example, if you can't find a criminal, you would notify through your state channels the Interpol to assist in apprehending, arresting this person. So I would think prima facie, it is a matter that needs to go through the state channels, because it is dealing with state channels, because it's an international enforcement agency. So I would think prima facie it is a matter that has to go through the channels of that particular nation.
All right. A lot of important things covered there. So we'll take a very short break. You're watching Law, Line and Liberty. Stay with us as we go deeper into this discussion of international relations and how international law really takes operation in the real world.
Hello, my name is Yehan and I am a sales executive. My question is on international courts. What is the mandate of international courts such as the ICJ and the ICC?
Welcome back to Law, Line and Liberty. We are in conversation with President's Counsel Seevali Amithirigala. Sir, we covered two very important areas pertaining to sort of like the bilateral connections, bilateral relationships. Now, taking a step back and looking at the overarching bodies that sort of look over all of this. Now, this debate about what the ICC is, the sort of mandate the ICC has, about what the ICJ is, what sort of mandate the ICJ has, it continuously keeps coming up. Now, in this specific scenario, sir, how does those mandates become relevant? As in, first of all, are the countries in the question party to the Roman Statute, which would be a part of the ICC?
Yes.
When it comes to the ICJ, it's a bit clearer, one would
Yes.
say. How do you exactly relate these institutions to the situation that
Yes.
we are discussing?
May I say the Sialkot incident at the moment is being dealt by the government of Pakistan, and the court process is also happening in Pakistan. Sri Lanka has officially no qualms as far as I can see from the media, and I don't think the Sri Lankan government should have officially any qualms, because I think upon the request of the Sri Lankan government and also upon their own cognisance, they have started proceeding into the case. We'll have to wait and watch what the outcome of that a case would be and how the perpetrators will be dealt, because it all happened in Pakistan. Yeah. So it is not a dispute between two countries. We don't have a dispute on a national or on an international level to take the matter to an international court. But from the perspective of the crime, let's say if the crime is a crime against humanity. So if you look at the crime is something that you would look and say it is an international crime. I agree. It is an international crime, but at the moment there is a domestic tribunal, a court, which is exercising jurisdiction over that. Now, with regard to the ICC, before I start the ICC and the ICJ, one must always come to the conclusion that international law is somewhat a weaker law comparatively to the other laws. Actually, philosophers such as Austin says it's not a law. They say it's pure positive morality. But I also agree to an extent, because if you take the ICJ also, there is no compulsory jurisdiction. Countries must consent. Everything depends on a country's consent to be bound by that. So even though there's contentious jurisdiction and advisory opinions, of course, which is not directly relevant to what you asked me, but contentious jurisdiction, if a country does not give their consent, you can't compulsorily exercise jurisdiction with regard to the ICJ. ICC has a better mandate, but then again, the question of compulsory jurisdiction arises there too. And, it is important to understand that having an international crime being probed is not only complicated, problematic, it is practically difficult, because you are bringing two nation states or more into dispute resolution, and how those nation states would react. And in their reaction, how some of them will be supported by powerful states is also another issue. Because generally to the ICC, matters would be referred by the Security Council. So if a Security Council is referring, then by that time the vetoes have been vetted and they have all agreed that this should go to the ICC. Then there is no complication. That very process of coming into that is a complicated thing, because powerful states would exercise vetoes. If the veto powers were not there, we would have prosecuted most of the international crimes more than what we are seeing at the moment. But then the veto powers are also having its own strengths in a different way. So I suppose in this scenario, there are international courts. And may I also add that there can be ad hoc courts, like for example, the Rwandan tribunals, the Yugoslav tribunals. You know, we saw how effectively justice was given, like for example, the John Paul Akisu case in the Rwandan tribunals. These were very effective forms of delivering justice. At the same time, you saw how Slobodan Milosevic was dealt also. So these international forums are of use. There is no doubt about it. But getting them started, triggering and getting the case going and apprehending criminals and getting states to come is difficult. And difficult does not mean impossible. So I think we have started on a good note, and I think it's very important to proceed. But then again saying, international law has to be implemented on a level playing field. I'm not talking about the courts, but referral to courts should be done without powerful countries selecting which one and which one should not be done. I hope I answered your question.
Yes, it's something that I just want to pick out from what you mentioned now. I think you were quite clear about the referencing method that happens to the ICC.
Yes.
And you did mention that when it comes to the ICJ, the state's consent, I think, in respect to their sovereignty, in respect to their own jurisdiction, is quite a big part that is in play. If we take a step back from this entire Sialkot incident and talk a bit about operations and procedure, how does the case in fact go to the ICJ, if I may ask? How does that entire process work? Because if I'm not mistaken, the ICJ is quite clear in mentioning that all domestic methods should have failed in order to come to that stage.
Yes. Yes. Actually, the ICJ jurisdiction is two-pronged. Number one, there is contentious jurisdiction where two states or even more can have an issue where there is a contentious issue that needs to be resolved. As I said earlier, there should be consent given by states for the ICJ to resolve. And once the matter has gone to the ICJ, then the ICJ will take cognizance on the matter, and the ICJ will decide on the legal issues from the perspective of, referring to treaties under Article 38 of the ICJ statute. If they have treaties relevant, they would take the treaties. If they are a customary international law, they will thereafter go to customary international law. If there are general principles of law that they have to go into, then they will go into them. Then thereafter, there are two other sources that they would go into. For example, judicial decisions that had been there before, although it's not binding on them, they would also go and tap on experts' opinions and writings also. So these are the sources that they would take in deliberating an issue once the matter goes to the ICJ. Of course, there is another method, which is another method where the ICJ would be working, but that would be giving advisory opinions. And those opinions, of course, can be sought by agencies of the United Nations. So therefore, that is different to the contentious jurisdiction.
All right, so in speaking a bit more about the role of these organizations, now when it comes to the domestic authorities, the courts have the police, they have government institutions to look into, to have the investigation done and all of that. When it comes to the ICJ or the ICC in regards to a criminal affair, what exactly are the resources available? What exactly is the court process that will be going ahead? Will it just be the reviewal of the domestic court proceedings, or is there some new element that is attached there? If you can just clarify to the layman what exactly happens in the ICC.
I think if you take the ICC, they have prosecutors, they lead evidence, and they will basically call the defense, and there is a fully fledged case going if it is the ICC. Even with regard to the ICJ, there would be instances where if that is required, that would be other than mere submissions of oral nature or written. What is important is to understand that the resources that are available to the ICC is also limited, if I may say, because the prosecutions don't happen to the extent what was thought would be when these were created. That would be associated with issues relating to resources, number one. And number two, I think it is also international politics, as I come back again to the same thing. So how you go about is accordingly, if it is a referral, then of course they would go as a prosecution if it's a prosecution. Let's say if it's the ICJ, and if it's a dispute relating to water, if it's a dispute relating to territory, then that would take a different ramification, all depending on the subject matter and the facts of the case.
All right. Again, another very important segment that we pass. So we'll join on the last segment and speak a bit about the remedies that are available in these regards, what we should be aware of when an individual maybe goes abroad to work, because these are some incidences that we have seen in the public forum for quite some time. Yeah, with Law, Land and Liberty. Stay with us.
Hello, my name is Devinder and I'm a law student. My question is on remedies for international crimes. What are the remedies available for crimes committed in foreign nations?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Seevali Amithirigala. So, our last segment, we are going to talk a bit about remedies for the crimes committed abroad. I think across the sections, we did touch on this quite a bit. Now, something that you also had mentioned, sir, was we have some form of responsibility towards ourselves when moving to another country, when engaging with another country, because clearly their methods, their cultures would be different.
Yes.
So, in understanding that, what should a citizen of Sri Lanka be aware of? What should they be thinking about? What should their entire thought process be when approaching moving abroad?
Well, before I begin this, may I say this, flattery, they say, is a cheap virtue. But I don't want to do this in the sense of flattery. But I'm invited today to a channel which is very much interested in the nationality, which is interested in our people. So I'm happy on the one hand, quite apart from flattery, to be part of this, and also to come into this channel and tell this, because I think the purpose of this channel is to take a message to our people. I think they are the most precious resource that we have at the moment. As I said earlier, as a nation state, we look at people who go abroad with a squint eye. We think they are going and making money and coming to look after the poor families. Well, from an economic perspective, that might be true. But I don't think we should be looking at our people through that kaleidoscope. We are sending men and women who are loved by their families, their children, their husbands, wives, mothers, fathers. When we send them, we as a nation state must, on the one hand, ensure that we are sending them, that they will be safe. Just as much as you and I, if we are studying abroad, or when we were studying abroad, when we were sent to the airport, how our parents were, letting us go. It's the same feeling for an ordinary person who's going to the airport. In fact, it's even more, because it's a daunting challenge for them. So there is always an instance where the government of this country can take upon itself to say, look here, I am sending you my nationals, not that you can really walk over them. True, we might be a third world country, a developing country, but don't underestimate our workforce. We are motivated. We are one of the most important workforces in this country, in the world. So therefore, if we are going to send you our workforce, jolly well, you will also agree to abide by certain basic conditions. You see, so as much as we have institutions like the Sri Lanka Foreign Bureau in here, where there is a lot of good work that is being done, I must say with great respect, I must say, the former government plus the present government, I must say, has indulged in this, making sure the people who are going, especially after the Rizana Nafik incident, that, agencies that are sending people are regulated. And that should continue. And, after the Sialkot incident, there is something very special we should really address our minds into. That is personal safety, number one. Number two, dignity of our people who are going in. If you can't guarantee the safety and dignity with which they would be treated, we shouldn't send people. So first and foremost, I think there is an important thing to be kept in mind. Labor, for example, labor migration agreements have to be formed between those institutions and between the regulatory agencies of our country. And our workforces who are going should not be jumping up and down trying to get the visa only. They should be really more vigilant and made aware. See where you're going to work, who's going to be your master, who's going to basically give you work, and what is your work, and what are your minimum protections. That's very, very important. Also, MOUs between Sri Lanka and these countries. From what I understood, there was no MOU between Sri Lanka and Pakistan covering managerial stuff. Okay. Workers, of course, are generally covered because we send workers on the within inverted commas workers. But these were managerial stuff. So it doesn't make any difference. Any national, we need to protect them. And it also includes the top management, as I said, coming down to the worker. And also, through the Sri Lanka Bureau of Foreign Employment, there must be registering of not only agencies, but these foreign companies who are getting our managers. And, MOUs must ensure not only labor standards and protection, the safety of the premises they were in. Mr. Kumara was dragged from the premises where he was in. So where can we expect safety for our nationals? As much as we see those two children and the wife, they are very sad today and crying for their loved ones. We as a nation must cry. We as a nation must also learn our nationals are not put out for any sort of abuse of this nature. So as a nation, we must ensure that, these safety standards are being brought in. And also, may I say that unionization is also not allowed in those countries for our workers. No. Unionization is a fundamental universal right. If the unionizations were allowed, then there would be collective bargaining and negotiating. Look, if they don't recognize that right, then at least allow our embassies to negotiate, allow our consular staff to negotiate and have bargaining power. Otherwise, it's a very unconscionable contract, no? Can we send our people for an unconscionable contract? You and I will be talking here because we belong to the privileged group. But there are lots of people who don't belong to the privileged group as you and I are. And those are the people who are sending their people. And those are the people who are suffering. Unfortunately, Mr. Kumara was also from a privileged group and he was susceptible. Just imagine the workforce. Just imagine our innocent housemates, our innocent workers who go there. If this is the fate that will befall on them, we as a nation should not keep quiet. We should tell them, if you can't guarantee the safety and dignity, we would not send you our workforce. Simple. It's a very simple answer.
All right. So something I want to get, I think, some very important thoughts there. Something that if you could clarify to us, if these families, the grieved parties, were to take some form of action in the event they believe that they are not getting the justice they deserve. Yes. What sort of remedies can they go to? Which authorities should they reach out to? Is it just the embassy? Is it just the diplomatic missions that we are going to reach out to? Or what can they do as of now?
Yes, I think I'm not very versed on this, actually, to be very honest, so forgive me if I'm making any error. I am not versed as to what sort of damages had been paid by the government of Pakistan yes. to Mr. Kumara's family. But I think there were a lot of discussions going on, reparations. Reparations of any kind should and must be made. But reparations alone can't make minds, no. We should ensure that Mr. Kumara's plight would not happen to anybody in the world. We are predominantly a nation of Buddhists. we should, as Buddhists and also as Christians, Muslims and Hindus who are also nationals of this country and to whom this country also belongs to, we should wish and pray that this sort of situation should not befall on anybody. Because the mere discussion makes us come to a very, how shall I say, a very negative mindset, you know. This type of treatment should not happen in this age. So first and foremost, because there is a trial that is going in Pakistan, coming into any preconceived notions about their judicial system would not be proper. So let the case go on. But I suppose if they are not satisfied with it, and I think they could reach out to other organizations, because why I say that is, this trial will be also monitored by other international agencies like, for example, Amnesty International, and I think also the UNHCR and also the Human Rights Council will also observe as to what is happening. So those are also agencies which can be taking a bigger part if by chance justice is not done. I wouldn't want to go there because I think, like my own country, Pakistan is also an independent country. She has her judicial system working, and for us to cast aspersions on their legal system would not be proper, because Pakistan, let me say this, Pakistan is a dear friend of the Republic of Sri Lanka. We are very good friends and we've had a very good diplomatic relations, and I believe we should be able to sort this out through a diplomatic channels.
Sir, as a final question for our discussion, if you were to give a message to the now, foreign employment is not something that we are going to forget about. It's going to be something that's going to be integral part of our country's economy. To those people, if you were to give some form of legal advice, what should they look into before moving abroad? What are the initial things, like the checks and balances that they should have amongst the conversation that they should have with themselves before making these steps, so that they are safe?
Yes, I am very thankful you invited me to talk about this and also this particular question. You know, before going into the legal aspect, there must be an attitudinal change. Attitudinal change must come in. I must not go abroad because I need money to bring up my family and so on. This seems to be the focal point. And everything other than getting a job is, ignored. So we have to make our people aware that this is not the way you should go about it. And that can't be made aware by you and I. It should also come through the government apparatus, saying we encourage you going abroad and making money and coming back. But that's not the only thing. You should worry about the place where you go. Is the place allowing you the safety? And can you also have an environment where your dignity will be preserved? Can you also have a place where you can believe what you believe, and there are certain limitations? For example, Saudi Arabia has certain limitations. Our people have gone to Saudi Arabia and existed. Apart from few incidents, we haven't had many others. I'm not saying the Rizana Nafi case was not an incident, it is. But what I'm trying to say is, even now if you look at it, Saudi Arabia has relaxed a lot of laws also for the people who are going into their countries. So it's very important to understand where we are going. What is their legal system? What sort of rights do they allow us? What shouldn't we violate in their country? And what should they give in return as protection when we go to those countries? This cannot be done by you and I, or for that instance, a media institution. Although the media can take this message across, it should be done by the state. But I am not saying state with a blameworthy attitude, because I am very, very, very strongly believing that the Sri Lankan governments have consecutively tried to do the best they can do in it. It is through the regulation of the agencies, and it's actually making people aware that you can really tell them, look here, you have to look after yourself when you're there. Because, before I conclude, may I say, in our culture, mothers, they partake their food at the end after treating and entertaining everybody in the house. This is the attitude that we have when they go abroad also. They suffer to give their children a better life. I understand that ethos, but that ethos should not be the governing criteria for her safety. Our people matter to us, you see. You matter to us because we are Sri Lankans, you see. If we don't look after our own, who would? So that's the reason why I think it's a social awareness, attitudinal change. I think the incident for what happened with Priyantha Kumara should not be repeated to anybody. And I don't think Sri Lanka should be standing for anything of that nature in the future.
All right, I think a very comprehensive take on this topic. Thank you so much, President's Counsel Seevali Amithirigala, for joining us. He's a lecturer in law and quite prominent within this field. Thank you so much, sir, for joining us.
Thank you very much. It was indeed a pleasure coming to you, being interviewed by somebody I had thought, and also coming to a media institution that I have a lot of respect. Thank you very much.
Thank you, sir. All right. The complex nature of crimes has led to increasing requirements for the law to keep up, sometimes across geographical borders. In relevance to today's topic, the former president of the International Criminal Court, Judge Sang Yung Song, explained the responsibility that is spread across all nations. He stated that, quote, the ICC is a court of last resort. States within their national jurisdiction always bear the primary responsibility to ensure accountability for serious crimes of concern to the international community as a whole. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/otherderana English. Join us again next week as we break down a contemporary legal topic. I'm Danny Zanawasa. Have a great night.